This one may be a bit of a tough question to answer, but can individual board members be found criminally or civilly liable?
Most of the time, like I alluded to the business judgment rule, a lot of times your board members are protected. It doesn't mean that someone can't file suit, but to survive.
Thank you, George, for joining me this morning. I appreciate you coming down from Tampa.
Thank you, Sam. Thanks for having me. I appreciate the opportunity.
So I was wondering if you could tell us a little bit about your background, first of all, and then we'll talk some more about condominiums here in Florida.
Well, I work with the Stockham Law Group. I've been doing condominium and HOA, community association, general counsel law for about 11 years now, and that's all I do. The rest of my firm does a lot of first-party insurance dispute work and property claims with insurance companies.
Sounds like people like that will be pretty busy here in the near future.
I think so, especially with Elsa just having come through. That always creates a lot of insurance issues and things for us to consult with. And, I have to get my general counsel clients prepared for the hurricane, and the rest of my firm helps them after the hurricane.
Yeah. Well, that's a topic for another video, insurance claims related to hurricanes. So we're having a lot of roof problems in Florida right now. People won't insure roofs that are more than a few years old because they got driven out of the state of Florida basically by Irma. So can you tell us a little bit about how condominiums are organized? And we're, just for your information at home, we're strictly talking about the state of Florida because that's where we live and work. Other states may have laws that vary, but in Florida, condominiums are not-for-profit corporations. Is that correct?
That's correct. And some of the concepts that apply here with community associations, with condominium associations, are probably true in a lot of states. When developers develop a condominium, one of the first things they do is record articles of incorporation with the state. They typically record the bylaws, the articles of incorporation, and the declaration with the county that they're building it in. And for those who don't know, the uninitiated, when you buy in a condominium complex, you're entering into a contract with the association. So that's why they have the right to enforce their covenants, their restrictions, their bylaws. There's a lot of things that govern condo boards and associations, what they're allowed to do. You've got your state and federal constitution, administrative bodies such as the Department of Business and Professional Regulation, case law that's developed through disputes and interpreting the statutes. Florida Statute 718 governs condominiums. Mm-hmm. We're also governed and have to comply with the Business Organization Statute, which I believe is 617. And a whole host of other regulations from SWIFT MUD to local county and city ordinances.
Interesting. It's a lot to consider for sure.
It keeps me busy and keeps me gainfully employed for sure.
Yeah, no doubt. Can you tell us a little bit about this recertification law that's on the books in Miami-Dade County?
Well, as I understand it, most of the state doesn't have these similar local ordinances. It's primarily in Miami-Dade and Broward County. And it was created several decades ago to recertify buildings that are at the 40-year mark. It doesn't apply to single-family residences. I believe some buildings that are less than 2,000 square feet are excluded. There are some exceptions and limitations there. But generally, any large buildings have to go through this 40-year certification process. So what I try to tell clients in that area of the state is that, if you're approaching the 40 years and you haven't gotten a notice yet, you need to start preparing for that and maybe find your engineer, your experts that are going to conduct that recertification inspection of the property.
Right. And nobody's saying, I don't think, that this should be the first time you look at your building in a structural, context.
100% agree. I encourage clients all the time. The Florida statutes 718 require you to fully fund your reserves unless you get a membership vote to do less than fully fund it. And I always caution my clients to fully fund it, to don't be afraid of raising assessments to meet your maintenance obligations. Part of your fiduciary duty is to maintain the common elements and the financial health of the association. And so you should be getting reserve studies. You should be inspecting your infrastructure and your common element components to make sure that they're in good shape. For financial reasons, too, the value of your property is going to be greater if it's a well-maintained condominium.
Right. And it's never cheaper later.
It certainly isn't. So many board members that I work with are afraid to raise assessments. They're afraid to fully fund their reserves. And I don't know if it comes from a place of they're afraid to lose their power position on the board, or they're afraid that membership can't bear the increases, but gradual incremental increases through the years to fully fund reserves and meet your obligations is a lot easier to manage than a $10,000, $50,000 special assessment when you realize that you haven't fully funded your reserves and you're unprepared to make these necessary repairs.
And I just want to clarify, you've been saying assessments. You mean that's, not a special assessment where you need more money all of a sudden, but your regularly scheduled installment payments that go to your general reserve fund.
Absolutely. When the board's putting together a proposed budget, they're looking at your regular common expenses, everything it takes to maintain on a day-to-day basis, lawn mowing, insurance, coverage, electricity, irrigation systems, pavements, parking lot, that kind of stuff. They've got a day-to-day operation fund that's part of their common assessment, and they're also a portion that's going towards reserves, long-term maintenance. Mm-hmm. So if a roof lasts 20 years and it's going to cost X amount to repair that roof, then 20 times how many ever months in the 20-year period, that's what you need to be collecting each month, and that amount is going to be divided by the total number of units. And so that's the formula they use to figure out how much of the regular assessment component needs to be going towards reserves. Special assessments are when you figure out that you messed up or you have unforeseen contingencies, and they do happen no matter how well-intentioned or how thorough a board is. Sometimes you do have the need for special assessments, and that's to cover unexpected construction expenses and maintenance and repairs generally. There's also specific assessments. That's where the board incurs maybe enforcement costs or abatement costs, and it's attributable to one unit, and then you vote to specifically assess that against that unit owner if you have the specific assessment right in your governing documents. But those are generally the three main type of assessments.
Yeah. In what situation would you think that a board might be reluctant to ask its members for a special assessment?
Well, as a practical concern, some special assessments are so high, not too many people can probably afford the type of assessments that are required when you have a tragic situation like Surfside, the necessary repairs there. I think I read that it was going to be $10,000 or $12,000 a person. If not, I don't know. I don't remember the numbers.
75 to 100,000, I believe.
That's even worse. I mean, I don't know many people in my life that can afford to take on that kind of financial obligation. So that's a tough sell for a board to convince membership that all these repairs are necessary. We're asking you to pay a special assessment that may be much more than the equity you have in a unit. In some of these situations, boards have to take a hard look at whether repair is the best option or if termination for a condominiums is the best option. So there's a lot of practical considerations and real life problems that lead to a situation like this. It's just not mistakes or bad decisions on the part of a professional or a board member. Some members simply can't afford to pay the special assessment that is necessary to maintain the integrity of the building. Those are the things you face on a day-to-day basis when you're trying to counsel your client through these situations.
Right. You mentioned the term termination. That's basically like we're done, everyone has to move.
It's a statutory mechanism for terminating a condominium, whether that's to turn it into an apartment complex or to demolish it because it's structurally unsound. It's a very specific statutory mechanism for going about doing that. And, in some scenarios, that may be the best decision. In other scenarios, a special assessment and trying to fix the underlying structural issues may be the best decision. But that's something to consider when you're faced with these type of problems.
And that might be something to, weave into the law that if the repair value exceeds the actual value of the building, could be something to look at.
And I'm far from a termination expert. Some of that language may be in there already. There may be under the condemnation provisions. There could be things at play that I'm just not familiar enough with there. But sometimes professionals can give a lot of good advice, but there's practical concerns that slow down or maybe keep folks from implementing as quickly or at all. When you have a tragedy like this, I think sometimes there's people are quick to point blame, but some things are tough to implement, tough to make happen, and absolutely, some of these things probably should have happened quicker. But there's the what we can take away from this is folks now know how serious their obligations are on boards.
Absolutely.
And I'm going to have an easier time convincing all my clients to do the necessary repairs, to get the engineering reports, to fully fund reserves. Some good will come out of this in that hopefully we can prevent these type of tragedies in the future. And I think there will be things happen in the 2022 session that kind of force us to do things differently.
So tell us a little bit about the board of directors. This is like the governing body of the corporation, essentially.
So when a developer sets up a condominium, they file the article of incorporation with the state creating the entity. And then your bylaws are kind of your procedural document that tell a board how to conduct board meetings, membership meetings, and their day-to-day operations. Your declaration is your covenants, architectural control elements, that kind of thing. But the board of directors, it's usually an odd number, anywhere from 3 to 7, 9 members, and these directors run the business of the association, and it's their job. They have a fiduciary duty to act in the best interest of their membership, and so that includes making sure that they're complying with all the laws that govern associations and preparing an adequate budget to meet all the association's needs. That's an oversimplification of it, but these folks are protected by business judgment rule, and it's within their purview to do what they think is in the best interest of the association, and they're encouraged to and protected by relying on professionals such as attorneys, engineers, other vendors in other areas that they contract with.
Right, and they take on the legal responsibility for work that they perform on behalf of the association, these professionals.
To a certain degree, that's why it's important that when you are interviewing and evaluating which vendors and professionals to hire, you want to take a look at whether they're fully insured, whether they're licensed, whether they're bonded, and whether they're credible, what their professional reputation is. Mm-hmm. What I always tell clients, the cheapest bid isn't always the best. I mean, sometimes you pay for what you get. When you go
Absolutely
parachuting, I don't think many people go to the counter and say, "Hey, can I get half off? And I'll jump with one of your less reliable parachutes if you'll give me half off." You shouldn't do the same thing with your condominium. I mean, you want the best available out there.
Absolutely, that's a good analogy. What's put to a vote when you have a condominium association? You have board members that regularly meet, and I would assume that the board meetings are probably open to the general, population of the condominium. What is required to have a vote, and what can the board do as a matter of business without votes from the ownership?
Well, I'll start by saying that all board meetings and board meetings where the board conducts the business of the association, and all membership meetings, that's a different type of meeting, have to be open to the membership. They have to be noticed and open. The only time you can have a closed meeting typically is if you're discussing pending or threatening litigation with an attorney or an internal personnel matter with association employees. Those are two of the exceptions. Generally, meetings have to be open. Membership votes at a membership meeting are triggered when you have an annual election, sometimes when you're specially assessing, if you're wanting to waive reserves. Some amendments usually require special membership meetings. And there's a few other scenarios, such as capital improvements and material alterations. Those are all usually things that trigger a membership vote. Mm-hmm. But most of the time, the business of the association is made, those decisions are made by the board. And as I understand it, most of the budgets are approved by the board unless your governing documents require membership approval of the budget.
Gotcha. And by capital improvements, material alterations is obviously like changing the color of the building. That would be something that everyone would have to vote on because they all live there and have an opinion. Putting on a new roof or something like that needs to be done and is part of your capital reserves that you've set aside funds for, those kind of things require a vote as well?
Not necessarily. You should consult general counsel every time to make sure that you're following the proper protocol. However, if you're changing like the type of tile you're using substantially, that's probably going to trigger a membership vote. Roof replacement's one thing. If you're changing like for like, that's probably not going to trigger the membership vote requirement. However, if you're doing a new paint color, as you mentioned, or changing from terracotta tile to architectural shingle, those are all things that probably necessitate a membership vote for approval.
All right. So What are some potential legal ramifications for buildings that miss or skip this recertification, or is that something that happens anyway?
Well, I'd like to start by saying that there's only a few areas in the state where you have to worry about this, unfortunately. And in those areas, typically the county or city will send you a notice out, essentially giving you 90 days to do the recertification inspection. Mm-hmm. If the recertification inspection identifies problems, structural integrity issues, that kind of thing, then you have 180 days to make those repairs, and then your engineer comes back, re-inspects, and then certifies if everything's done properly. After the initial 40-year one, that comes up every 10 years thereafter. So that's basically Broward County and Miami-Dade's regulations in that regard are pretty much similar.
Right. And I know from having worked at this company here that 180 days is a completely unrealistic time frame for getting any sort of repairs made, especially of a structural nature that require planning and bidding and lining up these contractors that actually do that scope of work.
I suspect that if you're proactively attacking this and not dragging your feet and you're communicating with the local governmental entity, that you can probably get extensions of time. Some of the penalties for not complying could be fining, condemnation, that kind of thing. So boards that are responsive and proactively reaching out and letting them know, hey, we've got this scheduled to happen, but it's not going to happen in the 180-day mark. Maybe there are allowances for that. Definitely showing that you're trying to fix the problem, address it, and not sticking your head in the sand will help you avoid some of the penalties related to noncompliance.
Why doesn't the rest of the state have a similar law or ordinance?
That's a good question. I think after the Surfside tragedy, I think maybe the next legislative session you'll see legislators address that. There'll be more pressure to address that. There's other things in addition to creating a statewide recertification process for aging buildings that could be done, that in addition to that would be making it harder for boards to not fully fund their reserves, making reserve studies mandatory. I think it's an industry standard or suggested practice to do reserve studies every 3 to 5 years. Maybe it's prudent to make reserve studies mandatory periodically, in addition to having the 40-year certification.
Have you heard anything about this grand jury that's been commissioned to investigate the collapse at the Surfside condominium?
I'm not that familiar with the grand jury having been put together down there to address this situation, but it's often when there are tragedies or things of this magnitude that a grand jury will investigate the facts and what happened to see if anything rises to the level of criminality that needs to be addressed. And I don't want to comment on I don't know the facts of the Surfside and what went down there as far as the background to be able to comment on that. But a grand jury serves a public purpose as far as a shield between a prosecutor and their commission to investigate. They have subpoena power, and they just take a look at everything, and then they can issue reports and findings at the end of their examination of the facts and witnesses.
Could an association be liable for not fulfilling their duties to the residents?
Absolutely. And there's a couple of different ways that liability would rear its head. You have a duty to maintain the common elements and follow the rules and regulations, whether it's state statutes or local ordinances. So that's one of the reasons that associations carry director and officers insurance, general liability, that kind of thing, because mistakes do happen. Even the most prudent person exercising the care of an ordinary person still makes mistakes. So yes, a homeowner could bring a breach of contract action if you're not properly fulfilling your obligations under the governing documents. They could file a declaratory action to have the court rule that this is how you're supposed to be acting. So, there's a number of ways. Also, if any unit owner that feels like they've breached their fiduciary duty or frolicked outside the scope of their authority can bring an action against them. So there is exposure. Mm-hmm. One thing I'd like to mention, boards are protected to a certain degree by the business judgment rule. It gives them broad latitude to make decisions that they feel are in the best interest of their membership in the association. They can rely on expert reports. To the extent, like if you're an engineer and you're relying on an expert report, and you're looking at that report, and you know that the underlying basis for it is faulty or that it's faulty reasoning, you couldn't rely on that. But if you don't otherwise have the special knowledge to understand that that expert report could be faulty, then you can rely on your credible experts, and it shields you, gives you some liability. You should use experts. Boards don't often enough rely on experts to make their decisions. They want to save $1,000 and not get an engineering report.
Right.
But when you're looking at $100,000 liability for an issue, what's a $1,000 report? They need to lean on their accountants, engineers, attorneys more often than they do.
Absolutely. That's one point I've been trying to make on a daily basis here. All right. So you mentioned insurance a moment ago. So in a liability type of situation, especially like what we have over in Surfside, is it the insurance companies that would bear the brunt of this, much in the way they did after the hurricane?
Well, as an association, you acquire a lot of different policies, and I'm far from an insurance expert, but generally these associations going to be carrying general liability policies, directors and officer policies, flood, hurricane policies, fidelity bonding for those that are handling money and funds of the association. So yes, conceivably, if you get sued for something, you hope that your carrier will pick up coverage, provide you a defense, and also, if there's any liability, pay your judgment. Sometimes your judgments can exceed liability, your coverage amounts. There's a lot of things that can happen. Sometimes insurance companies deny claims. If you're a board member who exceeded your scope or authority and were committing, criminal acts, that kind of thing, then your coverage may not, insurance may not provide coverage for some of those things. They try to decline coverage. And so, yes, insurance is going to bear a brunt here, but sometimes, you don't have coverage in certain situations, and the association needs to be prepared for that from a financial standpoint.
Okay. This one may be a bit of a tough question to answer, but can individual board members be found criminally or civilly liable?
Most of the time, like I alluded to the business judgment rule, a lot of times your board members are protected. It doesn't mean that someone can't file suit, but to survive motion dismiss stage, they're going to have to show that there was negligence on your part, more than just negligence, some misconduct. 718 even has some, Florida Statute 718, which governs condominiums, also has some criminal penalties built into it. For destroying official records, there's some criminal penalties. For falsifying financial information, for destroying ballots in elections. So there are some, for taking kickbacks, there are some criminal things built into the statute. As far as criminal liability, because you just didn't do a good job as a board member, that's probably going to be a little bit less likely than the civil liability. But you should be protected by the business judgment rule as long as you're relying on experts, you're doing your best to follow the rules and regulations, and you're acting within the scope of your authority. And I say that because I don't want board members to be afraid of being on the board. It's hard enough with voter membership apathy to get people to serve on a board.
Right.
But there are a lot of protections afforded by the business judgment rule, and that's why associations carry director and officer insurance. If you're doing your job and working hard and diligently and with the care of an ordinarily prudent person, there's going to be a lot of protections for you as a board member.
So one thing I was curious about was this neglect, when I'm specifically talking about the Surfside building now, Champlain Towers South. Obviously, the neglect started probably decades ago when these structural issues should have been at least evaluated, and if there were any, they should have been addressed probably long before the 40-year recertification. So in the case of board members that are long gone and board members that were serving, more recently, the neglect likely started years ago. So would the more recent board members have any sort of responsibility for something that somebody started or set in motion or didn't set in motion years ago?
Well, as a board member, I think it's important. The statute was changed a couple of years ago to require board certification courses to kind of teach you how to be a board member. Mm-hmm. Or you can sign an attestation saying you've read all the governing documents, understand them and the statutes, and agree to uphold them. I always encourage my clients to do both, a board certification course, I teach those all the time, and to do the attestation. Part of that is so that you understand your obligations as a board member, because when you come on board, you didn't create the problem, but you need to take care of it. You need to do what you can within your power to fix it and understand your duties and obligations. A board member from 20, 30 years ago, even if they contributed to the liability, you can't really go after them. There's a statute of limitations issue that probably applies for most causes of action. Maybe more recent board members that were culpable, they can share some of the blame. Maybe plaintiffs will go after them in addition. But you as a board member, understand your duties when you step in there. Ask for engineering reports. Look at the reserve studies. Talk about these things in a budget meeting. Don't just be a rubber stamp and try to go quietly without causing a stir. So a lot of board members take the job without fully understanding what their obligations are. And if they do that, right, then they'll help shield themselves and mitigate the risk involved with being on the board and mitigate the risk for the association as a whole. And that's what you're mainly trying to do all the time, is mitigate risk. I mean, part of my job as general counsel is to protect my clients and to help them avoid loss, risk, that kind of thing. So you're constantly coaching them up on how to be better board members.
I understand. So could the engineers that prepared this 2018 report or the 2021 repair protocols for the building, could they be held liable for any of their involvement?
I'd like to start by saying I don't know the intimate details of what happened in Surfside. I don't know how far back this goes. Obviously everyone that's ever been involved with that condominium complex is under a microscope now. Current board members, former board members, experts, attorneys, engineers, everybody that's ever been involved in it. And, I think we can take some lessons away from here, and this can help other people avoid similar tragedy. I'm going to be able to go all to my clients and have more force and be able to beg them not to less than fully fund reserves. Right. I'm going to be able to have an easier time encouraging them to get the necessary inspections. Just because you don't have to do something doesn't mean that you should, or I guess I said that poorly. Just because you can get away with something doesn't mean that you should. Like I said, reserve studies aren't necessarily mandatory in condominium world, but maybe they should be. Mm-hmm. Maybe boards should be proactively inspecting the building envelope, the structural integrity of the building. We're in Florida. Most of the buildings and condos in Florida are close to water. You have salt there that corrodes rebar, cementitious material, which is, you constantly have water leaks in condos from bursting pipes, from storms, from roof leaks. So there's potential for a Surfside situation all the time. So you have to be assiduous about doing your maintenance protocols, inspecting the building envelope, using engineers, using attorneys, using all kinds of professionals to make sure you avoid this. And one of the things that boards struggle with is, they don't want to raise assessments, but sometimes you have to meet your financial obligations, your fiduciary duty for the association. Otherwise, if Surfside, I don't want to speak on Surfside specifically because I'm not involved and I don't know what they did. Obviously, a tragedy happened. Maybe it could have been avoided with more maintenance protocols or quicker action, but we don't know that. What we can say is if folks are doing a better job of reserving and fully funding their association, then there's not the temptation to skip on repairs or delay them. Right. In Florida, how much you reserve for building repairs and maintenance is based on a formula between useful life of the component and the replacement cost. And there's some gray area with replacement cost. Depending on what kind of vendors you use, what reserve study you use, there could be a wide disagreement about the useful life of a component or the replacement cost. That's why I encourage constantly reevaluating that. If you have the money on hand to do the repair and replacement, you're more likely to do the necessary repairs instead of putting them off. No doubt. And you've pretty much answered the follow-up question to that question. What can associations and individual condo owners do to help protect themselves physically and legally in condominium buildings? Well, the Florida Statute 718.111, paragraph 11, mandates the type of insurance coverages. HO6 policies is what unit owners get, and it essentially covers everything from the unfinished drywall in. But don't be a passive member of your association. The board, the association, is getting the coverage for all the common elements. If you notice an issue, report it. If you notice the board's not doing the right thing, ask them about it. Go to these budget meetings. Ask questions about certain line items. If somebody's asking you to sign off on not fully funding the reserves, maybe you consider not agreeing to that. Absent membership approval, they have to fully fund reserves. So, I mean, there's things you can do as a member. You can serve on your board. There's not enough members out there willing to serve on the board.
Right.
And so sometimes you have to step up and agree to do this voluntary, unpaid position. It's tough. It's time consuming, but it ensures that you don't have a similar tragedy to Surfside, and it ensures that you can put your fingerprints on making sure your building's properly maintained.
Exactly. And most condominiums have committees as well as, just the board members, and you mentioned that boards are typically odd numbers. That's, I believe, to prevent tie votes. But then they also have subcommittees that are, like the building committee, for example. So there's other ways to become involved aside from, being an official board member.
Absolutely. So committees, serving on committees, just taking the time to communicate with your board and identifying issues. And if you see something, say something. I'm sure that inspectors weren't the first folks to see something wrong at Surfside.
Right.
People living there every day probably observe things that seem odd. So if something seems odd, let your board know about it, communicate to them, because most of the problems are identified through membership observance of violations or maintenance problems. The property manager, the attorney, those folks aren't on the ground every day looking at this stuff. The folks that live there are, so they kind of have a duty to communicate to the board and let them know what's going on.
All right. Well, I think that covers most of my questions. Do you have any any general additional information for anyone who lives in a condo or serves on a condominium board to, protect themselves and their association?
Use your professionals. Err on the side of doing more than you're required. Don't be afraid to raise assessments. In light of Surfside, I think we're going to have an easier time convincing folks to fully fund their association and reserves and do what's necessary to maintain the common elements and protect their membership.
All right, very good. Well, George, thank you for joining me today. I really appreciate you making the trip down here on this soggy post-errand day in Florida.
I appreciate it. Thanks for the opportunity, and I hope it's been helpful, and I hope going forward that the lessons learned from Surfside will help us all prevent this type of tragedy in the future.
Yeah, amen to that. And we'll have you back in the future to talk about another aspect of condominium law.
I sure hope so. Have a good day.
Thank you very much. Take care, everybody.